Welcome to the latest Evershed Sutherland Legal Insights podcast.
If it walks like an employee, talks like an employee, it's going to be an employee. Welcome back, everyone. We are excited to have you with us for our second episode of Conversations Across the Pond, where we will compare and discuss employment law in the US and Ireland. My name is Emma Quinn, and I'm an employment lawyer at Evershed Sutherland, based in our Dublin office. And I'm joined today by my colleague, Bonnie Burke, who is also an Evershed's employment lawyer based in our Atlanta office in the US. Bonnie, it's great to see you again.
Thanks, Emma. It's great to see you as well. I am missing our coffees from our last meeting when we actually got to see each other face to face in Dublin.
I suppose you could say, our conversations actually properly crossed the pond.
Speaking of pond, what did one ocean say to the other?
I don't know.
Nothing. They just waved. All right. It wouldn't be a podcast without me making a bad joke. So last time we discussed some of the laws and practices around job postings, interviews, and onboarding. Today, I think we're going to talk about the employment relationship beginning with the agreements. Emma, I know the Irish, much like the rest of Europe, is fond of their lengthy employment agreements. I always have a chuckle when somebody asks me to take a quick look at their European agreement and I have to peruse all 36 pages of it.
I know we do have a lot of employment legislation and, specific language and clauses that are either legally required or best practice that we want kind of captured in our agreements. I generally have a panic if an employer says to me, such and such an employee doesn't have a contract. I suppose I think employment agreements, they aren't really used as much in the US, are they?
Yeah, that's right. Most often employers will use an offer letter to set out the key terms of the employment arrangement, assuming that it's an employee they're offering work to and not an independent contractor.
So I suppose today, before we jump into the details of what really should be included in agreements, I think it's important to talk about the types of employment relationships that we most often see. So I suppose that is, you have your employee relationship, but you also have the engagement of independent contractors. And in Ireland, we would have an employment contract or we would have an independent contractor agreement. Would that be the same in the US?
Yeah, same in the US. If you're an independent contractor, you really should have a written employment agreement or written agreement for your services. And independent contractors have been a rather hot topic over the past few years in the US. We've had a change in the analysis that we use to determine whether a worker is an independent contractor. And then that test was changed again, purportedly back to the original test, but with a few modifications. But I think you've had a change in the testing standard in Ireland recently as well, no?
We had a really major case. You guys have Domino's Pizza in the US as well, of course. I mean, everyone has Domino's Pizza. We had a really kind of big Supreme Court decision at the end of last year, and it was kind of revenue commissioners took a case against this company called Carshan, who were trading as Domino's Pizza, and it kind of related to delivery drivers engaged under independent contractor agreements by Carshan. So in that case, ultimately, the Supreme Court decided that the evidence in the case pointed to Carshan having close control over the drivers, which created that employer-employer relationship. So it was really of huge importance to employers because it sets out this 5-stage test for establishing the existence of employment relationships. So it's really important that employers kind of consider applying that to their contractors. So I suppose the 5 steps are: does the contract involve the exchange of a wage? Has the worker agreed to provide their services personally, and can they subcontract their work? Does the business control what, how, when, and where the work is done? What do the facts and circumstances say about the true nature of the relationship? And is there any other legislation that would change the answers to any of the other questions? So I suppose, as I said, for Irish employers, it's really important to note that going forward, the courts really look at whether the employer has that close control over an individual. And I suppose, what about you, Bonnie? I suppose that's the current position in Ireland at the moment. What's the current legal position in the States when it comes to determining whether someone is an independent contractor?
Yeah, that close control is one of the factors we look at in the United States as well. In fact, the Irish test sounds a lot like the US test. I'll say that your fourth element there, looking at what the facts and circumstances say about the true nature of the relationship, is sort of the overarching theme of the test in the United States. We had some back and forth with our test of choice through the end of the Trump administration and the beginning of the Biden administration. But the current independent contractor test used by the US Department of Labor is what we call the economic realities test. And that test has several factors, none of which is independently determinative, but all will be considered and weighed toward the overall determination of whether someone appears to be more like an independent contractor or more like an employee. And so those factors are the worker's control over the manner in which the work will be performed. So looking at scheduling, supervising, price setting, those sorts of things. And that's kind of where that close control by the hiring entity is going to be looked at really closely. The worker's opportunity for profit or loss, and the amount of skill required for the work, the worker's investment in equipment or materials, the degree of permanence of the working relationship, and whether the work is an integral part of the employer's business. I mean, we could have a few podcasts just discussing each of those items, likely from the Irish side as well as the US side. But the thing is, the judges are not bound to use the DOL's test, right? So after they've gone through this back and forth, ultimately the courts can use other tests if they prefer. And we frequently see them use a test called the ABC test. And that test has three elements, kind of loosely on that, based on that economic realities test. So we look at whether control is absent, whether the business of the worker is usually performed by the hiring entity or unusually performed by the hiring entity. So basically, what is the business of that worker? And whether the worker is customarily engaged as an independent contractor in this trade or occupation. Just to make things even more interesting, not all of the courts that use the ABC test will use all three elements of that test. They may use or put emphasis on just two parts of that test. So an employing entity is going to want to think about these tests and how a court might view or determine independent contractor status when they're thinking about hiring someone as an independent contractor.
Bonnie, that sounds really similar to Ireland. It sounds like in the States, there are a lot of things that are considered. And it was in Ireland, there are other elements that we would take into consideration as well. So is there a mutuality of obligation? So that's really to what extent is there an obligation on a company to provide work and the contractor to accept and perform the work? You know, other things such as can the contractor send a substitute, or how much are they integrated into the business? Like all those things are also taken into consideration in Ireland, but a lot of emphasis at the moment is on that control piece.
Okay, interesting. And the emphasis used to be on control really heavily, probably still is in some courts. But we've seen some of the courts start to move a little bit away from just using that control element. So I've spoken with employers and contractors who think that if they want to be an independent contractor, that's enough. They have the free choice to decide how they want to be engaged or how to engage a worker. And it's just not that simple, unfortunately. If the worker is going to do the same work as an employee at the employing entity at the company, then they likely cannot be an independent contractor. There are exceptions to that based on some niche skills or circumstances, but generally, if the worker is doing the same work as other employees, if they're doing the work that is integral to the business of the employer, then they're likely going to be deemed an employee.
That's exactly the same in Ireland. I suppose what we're seeing a lot of is an independent contractor who works consistent hours with a company and sometimes even 40 hours a week. They don't work for any other company. They use employee equipment. And for us employment lawyers, the alarm bells are going off here. And if it walks like an employee, talks like an employee, it's going to be an employee.
Yeah.
And I suppose, like from our perspective as Irish employment lawyers, we're always saying to our clients, don't engage an independent contractor without a robust agreement that specifically outlines that you are not an employee and includes some really strong indemnities in the event that maybe the Irish Revenue Commissioners, the Workplace Relations Commission, in the event that they may find that the person is an employee, have those indemnities in your agreement. But would that be the same in the US?
Yeah, we do. If you're going to engage an independent contractor, it is a really good idea to have that written agreement and have those protections in place, especially if they are going to have any assistants or helpers. You don't want to end up running afoul of not only that independent contractor being deemed an employee who you didn't offer health insurance to, but also any assistants or helpers that they've employed along the way. So we do also, you want to have that written agreement. You want to make sure all the terms and conditions are spelled out, the indemnities, the insurance protections, and, explaining, even though it's not going to win the day, explaining that this is not an employee, that, the intent of the contract is to set up an independent contractor relationship, and that they don't have the authority to act on behalf of the employer and bind the employer without the employer's agreement. And also, we wouldn't refer to them as employers. Of course, it's going to be, that hiring entity, however you want to refer to them in that agreement. But yeah, that written agreement is key. And so I think when we're thinking about the difference between independent contractors and employees, we're kind of back to how we started the podcast today with kind of the best and most common ways of engaging employees. And I started by saying that most often in the US, employers will simply use an offer letter to capture those key terms of employment and reserve the use for our longer employment agreements for higher level management or executives. What about in Ireland?
In Ireland, we would have offer letters as well, but it's actually a legal requirement in Ireland that every employee has to be issued with an employment contract. And I suppose there's lots of different types of employment contract depending on the nature of the engagement. So, you have your permanent employees, your fixed term, your specified purpose. And I suppose similarly to the US, because I know you were saying that it's really just the senior kind of employees that would have employment contracts. We would have more robust employment contracts for those senior executives and C-suite employees.
Yeah, I've seen those, all 36 pages. So I think given how much is in those agreements, both in the US and particularly from the Irish perspective, we'll leave it here for today. I think when we speak again next, we'll talk about the contents of those offer letters, some basic components of employment, and those employment agreements, what should be in them under US law and Irish law.
So thanks everybody for listening to episode 2 of Conversations Across the Pond. Tune in next time for episode 3, where Bonnie and I are going to be discussing all things offer letters and employment contracts.
This podcast is presented by Eversheds Sutherland and is for informational purposes only. The content of this podcast is not intended to constitute legal advice or a recommended course of action in any given situation. This podcast is not intended to be and should not be relied upon by the recipient in making decisions of a legal nature with respect to the issues discussed herein. The listener is encouraged to consult independent legal counsel before making any decision or taking any action concerning the matters discussed in the podcast. This podcast does not create an attorney-client relationship between Eversheds Sutherland and the listener.